Bail in India today is more difficult than it was in British times. If money is the byproduct of hard work, then it's fragrance. When I got married, my wife said, I hate lies, and you are a lawyer. Look, these are larger issues. The bars normally react to them in trade union matter, but these are state level issues. And the disconnect in India is, bar council people are not lawyers. They are not concerned with our concerns. We have no access to them. This is one of the tragedies of this country. I've been dean law accidentally for some time. I've not seen senior lawyers, serious lawyers, subject experts being normally associated with the syllabus formation. So these issues actually are of concern, and I think lawyers at a body, if all of you have studied the latest draft amendments, some of them are dangerous, and we ought to apply mind to it, put them on our groups for discussion. Same about this also. So let me not assume the role of an expert here. I believe we will have to look into it, its feasibility, its desirability, and also most importantly to draw the line. I think probably the initial cases need a lot of hard work. I have my small diaries where I've noted God knows cases which are useless, hundreds of them sitting in the court. Somebody, even today, if somebody is quoted a judgment, if I don't note down the judgment, I note down the lawyer's case number, I ask him later. Case law is something which is a lawyer's lifeblood, particularly on legal issues, and it keeps changing today. Initial cases, early cases need a lot of hard work, many times more than what we would do eventually. That hard work will pay us. And second thing which I've always said, go to a friend of your standing, discuss your case with him. He'll tell you this is not a good argument. That interaction, which I'm calling partnership also, may take different forms. Go to a senior. I'm sure whenever a young lawyer has asked me something, I've only been bad in telling him day after tomorrow. I've always given him time. I remember a young lawyer, I don't remember the name. He came, he says, I have this hearing before the Supreme Court. I said, you will get a dismissal, but you will get a good hearing. I'll tell you how. So he came smiling, he says, I got a dismissal, but I got a lot of hearing. I said, since you're going, once you consult somebody, you interact with somebody who's more experienced, probably you will also be ready not to fight with the judge. If I've told you, you're not likely to get bail, you will not be peevish, you will not fight it out. But that will give you a kind of easy confidence of putting it across, because you're not worried about the result. You know it.
Sir, is writing under your own hand the same thing again? Is it a good idea, or is it reading it, only reading again and again?
No, I always write because I can't retain. Since I read a lot of things, make a note. In fact, you all know, when you have made a note by your own hand, you never forget. There are cases which I initially refused taking, but then the answer to your question is, I am now sharing with you something which you can as a lady appreciate. When I got married, my wife said, I hate lies, and you are a lawyer. I said, I don't tell lies. She says, how do you manage? How I manage, I am telling you. I'll tell the judge, there is no legal evidence justifying my conviction. And by telling him everything, and even if I don't tell, do you think the state council won't? Or the judges won't see through it? So what we really are doing is, that is why I said, when the case comes to you, first be a judge yourself. And if the answer your heart gives you is, it's a case of conviction, you won't be that disheartened losing it. So therefore, the second question you are saying is that happens in trial. Here we only have a paper book, we have legal evidence. Trial, court, sometimes the lawyer has to take a decision. There the line is, if he is within his professional limits, it's his duty to do so. And second, you all know, I have to keep in my bosom what my client has told me in confidence. That is the law. That is the privileged communication. So unless I have forged, I have fabricated, I have actively connived with my client in building a defense, I think I'm well within my rights as a lawyer. Try to. I'm not that lucky all the time. But over the week, about 5-6 hours. Over the weekend, about 5-6 hours. जी सर, आप किसी भाषा में भी सवाल पूछ सकते हो. If somebody has that hesitation.
We have talked about the importance of confidence in lawyer's life. There was a lecture in the bar room, a senior lawyer came from Delhi. He said that the importance, why is the courage, one should have a courage in life. So my point is that the importance of money is also, it is the money which makes the mayor money. How do you see the money, role of money in the profession?
You would probably know in one of the very popular books about lawyers, there is a case where the trial was on and the Queen's Counsel, the senior advocate, could not appear. He had a tragedy in the family. And a raw youngster got his chance who had prepared him, and he conducted the case and he won. It became a sensational case. Years later, they asked him, what were you thinking when you were starting that case? He says, I was thinking that my son had tugged me at my gown in the morning and asked me for something. Papa, please get me that today. See, money is of course there. Money is there for the doctor also, who is doing a very ethical profession. It's there for the teacher also. But I think, if money is the byproduct of hard work, then it's fragrance. I don't think money can be motivation as such. Initially it might be. Money may be a necessity at one time. Some people may have a lot of fascination for money. But at the end of the day, lucky is the lawyer who enjoys his work and money is the byproduct. I mean, that is where I would like to reach in life. They are doing better, ma'am. Ma'am, they are doing much better. Because they have to catch up. They are charging their price from the history of deprivation. They are doing better. First thing, I have no explanation to offer. It's bad. I still do it occasionally, let me tell you. But I don't do it as frequently as I did because no other people join. But the seniors, I'm not talking of designate, are not doing their duty. They should step in. As I still try to do it. But you know, when one does it, one looks at the judge and assesses, will it be worthwhile? In very crude language, can he be educated? So that's one. Two is, I think the seniors should take this burden. The seniors should stand by young lawyers. And particularly, more important than this is when a young lawyer has done very well, argued a case very well, not got the relief, it's the duty of his senior to wait outside, to find that young lawyer and to compliment him. I sometimes remember, sometimes I miss it, but I always feel this ought to be done. We need a lot more camaraderie, lot more encouragement, lot more feeling of brotherhood, now sisterhood, because you are sounding aggrieved on that.
And the second part, suppose if the seniors are not defending the youngster, and there is a very, very abominable remark by the judge, or maybe the opposite counsel, how does junior without being disrespectful to everybody?
Ma'am, that's a very difficult question. You know, most probably at that young age, at my age, I sometimes can be very sweetly vicious to the judge. Because then he is the one who's stung hard. One of my remarks is often recalled in the bar. There was a judge, whenever you read the first witness, he would say, Cheema, main batata hu kya hua tha. And before you read, he would start. And one day I said, my lords, main to wahan nahi tha, mujhe to pata nahi. But this you learn, you know, after a long patience. I would still ask juniors not to retort. See, this may be remembered. But if they have their composure, if they can be restrained, it will be wonderful if they stand up their ground. But usually I think the senior, that is where we are now handicapped by the bar association. That is one part where I think we now have a total vacuum. Because a judge would immediately appreciate if the bar office bearers have gone to him and said, this we have received. That layer of protection has to be revived. I think what we can add to that, we can have programs in the bar where we call judges, we have seminars organized internally, because if you can interact with the judges on a healthy note, I think that will probably build up a more congenial atmosphere. You've almost answered your question. You have narrated something I think we should all note and learn from. My God, Shivran, you will also ask me a question. Come on.
I had the opportunity of assisting with a pro bono matter last week, and that begs the question. You've spoken of three professions: teachers, doctors, and lawyers, all which have a public service in it. How does one balance that public service elements with the commercial necessity of running a practice, paying your juniors and associates, and having a good...
Look at Shivran. This is like saying how much conscience you should have. See, you cannot have a measure of it. There will be some people who will be compassionate. There will be some people who will not charge a poor client. There will be sometimes you would say this matter was not heard. This will be a matter of individual morality. And my regret is, in goodness, in humanness, in compassion, we are going down. We are going down. Our mercy or pity, words I don't like, our compassion for the man in trouble, we are bothered less and less. I don't know why as a society, if you switch on those 24/7 channels in the evening, they'll place before you dead bodies, scooty into car, truck into this into that. This has made tragedy so routine for us. We have become immune to human pain. And all young lawyers, I must tell, thanks for saying that, at all times, I have made 10% pro bono work as my principle. I want it more. In fact, when I become 80 technically, I think I want to do 50% at least, if not more. Please make it a point to do some pro bono work. It will ennoble you. It will enrich you as a human being, and it will give you a kind of happiness. which you would not experience by any other good case. Even in cases like Sajan Kumar, we were charging a pittance, not even the conveyance and back. But those are the cases which have given me the greatest joys of my life.
So most of us young lawyers usually get bail matters.
You are not that young, my dear, sorry.
I'm young to the bar. Most of the young lawyers will get bail matters, sir. But the tragedy is that in some matters where anticipatory bail would have been granted in the first go, if the person is unfortunately arrested, he does not get bail for 3-4 months. Why is it so that the jail is treated as if it is a resort and liberty is not acknowledged as much as it is in the books?
That is for another day. I'll be there because bail jurisprudence in India, I said it in the presence of Supreme Court cases. There was a Bar Council of India seminar in Delhi. I'll only make one remark. Bail in India today is more difficult than it was in British times. And that is a very sad commentary because the post-constitution India with Article 21 there should not countenance this situation. There was a sentence which I must not share publicly. I was defending a judicial officer in a contempt matter. So the Honorable Judge said, how do you justify this? I said, I don't. But I say no contempt is made out. He says, should he have done it? I said, the sad thing is doctors are insensitive to pain and judges to injustice. Now that is a sentence I spoke in agitation, but that is a sentence which rekindles in my mind sometimes. The ease with which a very normal bail is rejected, it's somebody else's case, it disturbs me. We are very, very careless on individual liberty.